Today I'm going to be going over some information about Section 504 and transitioning for students in later webinars. This particular one I'm going to do for the Utah Parent Center is Section 504 updates and students with medical disabilities. I'm going to start with a quick review of Section 504, and just so that you're aware, there are 5 parts to the Section 504 regulations, and Subpart D is the one for preschool through elementary and secondary education. The Subpart E are requirements for post-secondary education. So those are the parts that are the most important to us as parents. So who can be eligible for 504? A student that's disabled, and the definition is if the student has a physical or mental impairment that substantially limits one or more major life activities, the student has a record of such impairment, or the student is regarded as having such an impairment. Those are 3 criteria that can be looked at. We most oftenly look at the substantially limits one or more major life activity for schools. So there's often sometimes impairments or disabilities that may occur for a short period of time, and although that's not considered a disability, it's a student with an impairment that has a shorter duration still may require a 504 plan during that time, and I'll share some of those with you. So the student's eligible for 504 accommodation if the evaluation shows that the student has a mental or physical impairment that does substantially limit one or more major life activity. It also can include a major bodily function, and if it impacts the student's education. So no medical diagnosis is required for 504 eligibility. However, it's often a good idea to allow the school to have the school nurse or somebody talk to a doctor to see if there's certain accommodations that your child might need that is helpful to them to have all of that information. That's totally your decision, but it is very helpful for the schools to have the whole picture. So what are some of the major life activities that could be limited? So caring for oneself, performing manual tasks, as well as seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, as well as concentration, thinking, communicating, and working. In 2010, when they did the ADA Amendment Act, the updated one, they added major bodily functions that also may limit a major life activity. So those can be things that are related to the immune system, normal cell growth, digestive, bowel, bladder, neurological conditions with the brain, respiratory, circulatory, endocrine, and reproductive functions. So all of those things could help find a student eligible for 504 accommodations. So some of those disabilities that can be substantially limiting can include the following, and it's a non-exhaustive list because disabilities can be added to it. But currently the OCR has autism, cancer, cerebral palsy, diabetes, epilepsy, HIV and AIDS, attention deficit disorder, attention deficit hyperactivity disorder, central auditory processing disorder, obesity, multiple sclerosis, muscular dystrophy, major depression, bipolar disorder, post-traumatic stress disorder, and schizophrenia. So those are some disabilities, if a student has, they could qualify for a 504. Also, things that can be substantially limiting are things that work with the muscular and skeletal system for reaching, sitting, and interacting with others. So just keep those in mind as well. So 504, just so you're aware, also is held to the child find law, where the school is held liable to identify and locate and evaluate children that might have a disability. As parents, we are the first advocate for our kids but the school also has that obligation. They also are required to provide FAPE, the free appropriate public education. And I just wanted you to be aware of that. Those are the same requirements of an IDEA eligibility for an IEP. So what might red flags be that a student would need a 504 plan? So when a student is evaluated and does not qualify for special education services under IDEA, they still may need some accommodations to be successful at school. So that would be something to look at eligibility. When a parent frequently expresses concern about their child's performance, so when you as parents are doing that, that should be a red flag to the school. When suspension or expulsion is being considered for a student, that could be a red flag, especially if the student has had a lot of behavior issues. When retention's being considered, do they need a 504 plan to help them access the curriculum? When a student shows a pattern of not benefiting from classroom instruction, test scores are low, grades are low, work they turn in is limited. When a student returns to school after a serious illness or injury, they may need some help to get back up to speed at school, or may need some accommodations to recuperate from that illness. So also when a student exhibits a chronic health condition, that is a huge red flag for possible 504 eligibility. When a student has ADHD or ADD and are really struggling in school, that would be a red flag for a possible 504 evaluation. When substance abuse is an issue, a student may qualify for a 504. However, they have to have stopped using the substance or should either be in rehabilitation or have gone through the rehabilitation process to be eligible. When a disability of any kind is known or suspected, when a new building or remodeling is being considered, they should take into consideration possible disabilities of students that will be attending there. And when a student shows a pattern of not benefiting from classroom instruction or continual falling grades. One thing to note when there's a 504 evaluation is the school cannot look at mitigating measures. So if there's a student, for example, that has ADHD and they're on medication, the school has to look at the child as though they are not taking the medication to find them eligible for 504. Those things can include medical supplies, low vision devices, but that doesn't include ordinary eyeglasses. Prosthetics, hearing aids, implants, mobility devices, oxygen therapy, the use of assistive technology, learned behavioral or adaptive neurological modifications, surgical interventions. All of those things cannot be taken into consideration for eligibility for a Section 504. So what things should a school look at when completing a Section 504 evaluation? So the school may choose to use the same process to evaluate as they do for a student for IDEA eligibility. But whatever tests are used for 504, they should be chosen so that the tests accurately reflect the student's aptitude and achievement. The 504 team should draw information from a variety of sources. So that could be, observations, it can be achievement tests, teacher recommendation, social and cultural background and adaptive behavior, evaluations. All of those things can be taken into consideration for a 504 eligibility. So I talked a little bit about how a red flag would be a student with a medical disability. So I'm going to talk a little bit about that specifically because that is the area where a lot of the complaints coming to the State Office of Ed as well as OCR are coming. So I'm going to share with you a few court cases that have come up with this particular issue of medical needs and excessive absences. So in Hamilton, Ohio, there's a school district that the OCR did an investigation at, and the school was aware of a first grade student who had absences related to her chronic hypoglycemia and migraines. And they still began truancy proceedings against her and reassigned her to an online program. Her parents filed due process alleging that the district denied her daughter FAPE, and OCR stated that Section 504 requires districts to provide qualified students with disabilities FAPE. So the investigation found that the school district habitually failed to evaluate students for 504 eligibility after becoming aware of the students' physical and mental impairments that impacted their attendance. So our kids who have those medical disabilities, this is an OCR case, and this is one that we follow guidance for. So just be aware of that. So what steps should a school take to evaluate a student with medical disabilities? They should train their staff on the child find duty, and it's often good. The attendance secretary is often one that knows information about the student because that's who parents call to have their absences excused, and that person could give that information to the 504 monitoring officer at the school so that they can contact the parents and let them know what the school's obligation is to evaluate. Parents can also bring that to the forefront at the school as well. So then the school should gather information from parents. Teachers and staff can also give feedback and input, but the school must do their best to gather information from parents. One thing that we encourage schools to do is keep documentation of their efforts, phone calls, emails, letters to gather that information. That way they're covered, and parents, I encourage you to keep documentation too. So in case you ever did have to file a complaint with the Office for Civil Rights or the Utah State Office of Education. Then they can take and evaluate the student for 504 eligibility, and this occurs even if the student already has a health plan. If there's a student on a health plan and they're struggling at school, they probably also need a 504 plan for accommodations to help them access the curriculum. Maybe they miss school a lot, and so then they would need a way to make up the curriculum they're missing. Maybe that's through packets that are sent home. Maybe that's done through, a peer helping them. There's a lot of different ways, but to help students access the curriculum. Then it's always, like I said earlier, we encourage them to ask to speak to the student's medical provider, and that can be done with the school nurse if you prefer. It's just a good way for the school to totally understand what's going on with your child. I know as a parent of students that have disabilities, of children that have disabilities, that sometimes my emotions get in the way of expressing the information from the doctors. So it's really good to let them hear that firsthand from the doctors. And again, that is your right to choose to allow them to talk to the doctor or not. And then the school should convene a Section 504 team with all of those who have knowledge about that child or that student. So, and that team would most likely consist of the principal, school nurse, parents, and teachers. And it may include the student as well, depending on their age. This team would know about how their medical condition impacts the student's learning and attendance. That would be important for that team to understand. So here's another OCR case, and again, we follow OCR guidance in our schools and in our districts. So this one was in Yosemite, California, in the Unified School District. This was also a student with migraine headaches and had asked for requests for enrollment in independent work study. And when they did that, that should have promoted the school to do a Section 504 evaluation for that student. So OCR found that this misstep resulted in denial of FAPE. So the district should have policies and procedures in place to serve students with medical needs. One thing to note is, once the school knows that a student will be missing a lot of school due to a medical disability, they should convene the 504 team so that they can develop a plan to best assist that student. So the team should discuss ways to diminish symptoms during the school day. And according to Nathania Simon, a school attorney, it's the school's obligation to convene a meeting and make sure there is documentation and consultation with parent before they make any changes that will affect the child's education on a daily basis. So anytime that there's a need to change a student's 504 plan, which that team can be convened often, and it should be, especially with a kid with a medical disability that may present itself differently during different times of the year. So, and again, so if that 504 plan's not successful and the least restrictive environment is homebound instruction, then that's something that can be looked at under a 504 accommodation. So what is the difference between home instruction and homebound service? Home instruction is a placement on the least restrictive environment continuum. That's where a tutor is provided for the number of hours a week a student needs to have access to the curriculum and be successful. Homebound is available to all students with temporary illnesses and injuries regardless of their disability status. So in the state of Utah, Law 277-419-5A F II says, have direct instructional contact with a licensed educator provided by the LEA at an LEA-sponsored center for tutorial assistant or at the student's place of residence or convalescence for at least 120 minutes, that's 2 hours each week, during an expected period of absence. So physically excused from such a facility for an extended period of time due to injury, illness, surgery, suspension, pregnancy, pending court investigation or action, or an LEA determination that home instruction is necessary. And again, with a student with a disability, the minimum is 2 hours per week, but if they have a 504 plan, that may be more hours a week, just like a student that's on an IEP may receive more hours, depending on what they need to access the curriculum and be successful. So can homebound students participate in school activities? There's another OCR case in 2012 in Logan County Board of Education in Virginia, West Virginia, and a school district barred a homebound high schooler from entering a senior dance. They stated if he was too sick to attend, he was too sick to attend the dance. The court state that denying the student's entrance into the dance could be seen as a pattern of exclusion. So at the very least, even a temporary disabling condition is covered under Section 504. So not allowing a homebound student with a disability to participate in school activities can amount to disability discrimination. I mean, you may have a kid who has social anxieties or bipolar or some other disability that they're home for, and you want them to be able to have some social opportunities to help them be able to transition back to school. So what can a school district do to prevent possible discrimination for homebound students? They can provide them with notice of school activities, discuss extracurricular activities at 504 meetings, look at the student's ability to participate in those activities individually. OCR does not like blanket statements such as if you're too sick to come, you're too sick to attend these events. So there is one caveat, and that is if the student's contagious, that would be something that the school would consult with the school nurse, and maybe the student wouldn't be allowed to come based on their level of contagion. So you know when to reconsider whether homebound placement is still the student's LRE. Sometimes the student might be doing better in home instruction, and maybe they can start transitioning back to school for 1 or 2 classes a day and increase that as they do well, because we always want our kids to be educated in the least restrictive environment where they have opportunities for social as well as group learning. So when the school considers a major life activity, especially for a student with a medical disability, they can't just look at learning. There have been some students that have had things like concussions, irritable bowel, different disabilities that don't affect their learning. They could have scored 4s on all their state testing, getting A's and B's in school, but that doesn't mean that they're not eligible for a 504. So the districts cannot just look at learning. And if they do just look at learning as substantially limiting disability, then they could be in violation of disability discrimination. There was a court case a case in Memphis that's an OCR case, and the school took the position that a kid with asthma only qualified for 504 if their disability impacted learning. Because of that, they were found that they had discriminated based on a disability because they did not look at breathing as a substantially limiting life activity. So here's just one more OCR case, and that is a student who was diagnosed with irritable bowel and another digestive condition was denied eligibility of 504. And the OCR found the school in violation of that law because the school only considered learning in that case as well, and they should have been looking at the major life activity of the digestive system as well. So they found that the school didn't consider that the condition caused frequent absences and a declining GPA. So, and when they did look at that, the condition did substantially limit his learning. Sometimes we have students that just have episodic impairments. Those could be seasonal allergies, asthma, migraine, cystic fibrosis. Schools don't commonly qualify students under 504 if the condition rises to a level of substantially limiting a major life activity, even if it's episodic. And Congress, according to Dave Richards, who is a school lawyer out of Texas, says that students will not be found eligible because at the time of the evaluation, the student did not have the disability that substantially limited that major life activity. So what our guidance is then is that when the school does a 504 evaluation, they should look at the disability based on how it presents itself at particular times of the year. So here's another OCR case, and this case is a student who was absent due to multiple severe disabilities, and the mom had requested that the student be put on automatic homebound services during ragweed season and times when he had other disabilities-related illnesses. The district had a policy in place that said a student with an IEP or Section 504 plan had to accumulate 15 days of school, missing 15 days of school before a homebound placement could be requested. So OCR found that the district violated 504, their refusal to modify their policies to provide the student educational services for foreseeable absences related to the reoccurring or episodic conditions unnecessarily delayed the students receiving needed services. So Terry Engler, who's also a school attorney, says that strict adherence to such rules or policy is likely to be incongruent with both laws, referring to IDEA and Section 504, requirements of making student-centered decisions based on individual needs. So should schools modify policies based on individual students' needs? Yes, the guidance from OCR is that they should look at each student on an individual basis, and policies can be modified to accommodate a student. So, and one reason you want that accommodation, for example, to do with absences with a medical disability is, you know, one teacher might not mark that student absent because they're doing all their work and turning it in, and another will. So you want to make sure that all teachers and staff know how that policy was modified and that they are all consistent with that. And most importantly, they're encouraged to communicate with parents and foster trust and encourage them to speak to them when there's problems with their child or with the 504 plan. So a student with a mental illness should be evaluated for Section 504. It's a medical condition, so you follow the procedures for a student with a medical condition. And our guidance tells us from OCR that a student with a mental disability such as bipolar disorder is almost always eligible according to the OCR. Other disabilities that OCR has stated would almost always be eligible for 504 include epilepsy, cystic fibrosis, and diabetes as well. So for a student with bipolar, learning, concentrating, sleeping, caring for themselves, and interacting with others may also be things to look at in providing a 504 evaluation. And again, always keep good documentation as parents, and schools are encouraged to do that as well. So with a student with mental disabilities, again, eligibility should not just be based on grades. The school should acquire as much information as possible from parents, and again are encouraged to ask for permission to speak to medical providers, but to consider the parent input as well. So, and then strategies should be discussed with teachers. So for example, a student who's experienced mood swings may have a hard time getting started on an assignment. So the teacher could break that assignment down into small steps and then could assist the student in completing each step. So this is the end of this 504 review and students with medical disabilities. Again, my name's Jennifer Slade. I work at the Utah State Office of Education, and there will be a PowerPoint that you'll be able to follow along with this short recording, and it has all of my contact information. Thank you.